with your Lordship's consent, may I mention one matter from the list, your Lordship, because at item number 28, your Lordship, one IA is on board, IA number 10518, your Lordship, of 2024. Now we have filed this, your Lordship, because our bank account, the bank account of the petitioner, Bokaro Mahila College, it has been freezed, your Lordship. We have challenged the order of attachment, and this has been done for non-payment of dues for Provident Fund, my lords, which is amounting to 1 crore 35 lakhs and odd amount, your Lordship. We have already paid 85% of the amount. We have brought all those things on record, your Lordship. I'm only praying this may be taken up to date, my lords. Because
pleadings are complete?
Pleadings are complete, my lords. We have just filed this IA, your Lordship, and they have to respond, my lords.
Come at 250.
250.
Inform the other side.
From the list, my lord. From the list, here are now 3, my lord. In this case, my lord, I prefer 215, my lord. Online.
Who is for the other side?
Mr. Nipun Doxy.
Inform him.
I am for the respondent, Mrs. M.
You
Palis, to
inform
argue this
him.
case, my lord.
You inform him.
Yes, my lord. Just now I
It will be taken up at the meeting. But the case will be called out and I'll just simply post it at the meeting. Right?
Online.
From date list for final disposal item 1, WPL 499 of 2009.
Yes.
This case is sorted also.
Pass over.
Sorted.
Who will argue this case?
Senior GM is here.
Who is for the other side?
My lord.
Are you there?
Babsi is for the other side, my
Where is he?
lord. He, due to some personal reason, my lord, he'll be available in the second half, my lord.
We'll post it. Come in the second.
Second. Okay.
Item 2, WPC 4768 of 2010.
May it please, Amit. Because this challenge, initially at the time when the writ petition was filed, was to conversion of my consumer category from domestic service to commercial. Second challenge was to the inspection, and the third challenge was to the compensatory bill, which they say load inspection bill, that was under challenge.
I've forgotten electricity by now.
I rather would take privilege to argue electricity and tax matter before my lords. If I correctly remember, the first electricity matter which in length I had heard arguments was in electricity forum, and I was with my lords that time. So
With the passage of time, you are not updated in many things.
I understand. So as I said, I'll just very briefly narrate the facts of the case and then take my lords to the law point. The petitioner is
You
having...
narrate the law first. You narrate the law first.
Section 126 of the Electricity Act, to be read with Section 50, to be read with Section 181 2X of the Electricity Act, which would govern my case. Now, when I say Section 126, that pertains to assessment, but power to carry out assessment is drawn from Section 50, and this Section 50 is exercised by the Electricity Regulatory Commission in terms of Section 181 2X. If my lords would take up the Electricity Act for a moment.
Yes. (181).
181, it's the powers of the State Commission to make regulations.
Electricity Supply Code under section.
No, yes, madam. Electricity Supply Code is to be formulated by the Electricity Regulatory Commission. Now, Section 50 is the Electric Supply Code by which a licensee is governed. There is no conflict, there is no dispute about it. Now, what happens is, assuming for a moment, I'm not in this matter, but in general, the provision of Section 126, how it is attracted. The licensee who has given me the power supply, he on an inspection comes to a finding that you are using excess load as compared to the load actually for which you are entitled to. Then what he will do is, he will carry out the inspection, draw an inspection report, and after recording his satisfaction that this actually needs a adjudication or assessment of loss, if any, he will issue a provisional bill to me on which I have a time period on which I have to make an
respond.
objection.
That's right.
Now, when I make an objection, they will give me an opportunity of hearing. Whatever objection I raise, that will be considered to their satisfaction or to their or not to their satisfaction. A reasoned order will be passed, which will be said provisional final assessment. Thereafter, if I am aggrieved, then I will prefer an appeal in terms of section 127. This is what the law says.
Appeal before the forum.
Before the chief electrical inspector notified by the regulatory commission in consonance with the energy department.
127.
127.
Appeal
Yes, ma'am.
goes to the electricity regulatory.
No, chief electrical inspector.
Chief electrical.
Yes, ma'am.
Okay. It does not go to the regular forum.
No. There is a restriction, inbuilt restriction in the supply code to be read with the guidelines framed by the regulatory commission by which the forum is established, that 126 and 135 matters cannot go before the electricity forum.
Fair enough. So what happened in this case?
Now what happened in this case? I have a sweet shop at Gumla, and from the sweet shop my residence is 200 yards. Not in dispute, they also admit in their counter affidavit. They carry out an inspection in my residential premises. If my lord comes to the inspection report for a
You
moment,
have completed your all the
readings.
No, 127 also you have.
No, because that stage never came.
Okay.
That stage never came, Mills. That is why, Mills,
Let
because
us see the inspection report.
page 33, Mills, the typed copy is also there. Page 33.
Okay.
May I place it, Mills?
Typed copy is a true copy?
It's a true copy, Mills. Because that point of time I used to type myself, so I'm sure about it.
I still type myself.
Mills, I also do it. If I have to check any petition, I still do
If
it.
I have to correct an order, I do it myself.
Well, we are accustomed.
Yes, please.
नहीं तो आपने जो गीजर का स्पेलिंग लिखा है वही लिखे यार. So the type copy is there. The details of load, if my lords would see.
Okay.
Column 7. Geyser, GFL, this should be CFL although.
Okay.
Fan, mixie, bulb, tube, refrigerator, electric iron, TV, pump motor, exhaust fan. The total load ascertained is 5969, they total it to 6 kilowatt. Now in the bottom, they make a note. Suite workshop running in this camp. And this is what led them to issue a provisional load inspection bill, which is the next page, page 34.
Yes. They convert it.
They convert my tariff category from DS to NDS. No reason why it has been converted and how do they arrive at a figure of 180 to 142.
So there are two grievances. One is that it is converted from domestic to a commercial category.
Yes, Manoj?
And the other is the quantum.
Quantum.
If you are running a sweet shop,
No,
what is
they
the-
do not say I am running a sweet shop from the premises. What they say is sweet workshop running in this camp. Now the question, as per my understanding to the little knowledge I have, if at all I am carrying out any sale, then it's a commercial activity. If in my residential house I am preparing it, taking it to my shop and selling it, then it cannot be treated to be a non-domestic service. Now there is an admission why I say if my lord comes to their counter affidavit, it's very categorical.
We'll come to the counter affidavit later.
Yes, my lord.
So your contention is that in the house, wherever you are residing,
Yes,
you are preparing sweets.
yes,
That is not a commercial place.
absolutely, my lord.
It becomes commercial when
Only-
it goes to the shop
Yes,
and there is public dealing at that.
correct, my lord. Much obliged. Now, my lords, when they raise this bill, my lords, I approach this honorable court. This honorable court directs me because my electrical connection was discontinued. My lords, I was directed to deposit 50,000 rupees for the purpose of restoration, which I deposited. My electrical connection was restored.
So where is that order?
My lords, that order of my lords Justice R.K. Merit here is at order number if
During
minutes,
the pendency of this case.
minutes at the first stage
Oh,
it was
that's
passed.
okay. I thought that there was another.
No, minutes at the first instance
Okay,
it
you
was passed.
deposited that amount and you have an interim order.
Yes.
That is continuing.
Yes. Now, minutes during the pendency, once they issued me a disconnection notice, although there was an interim order, I preferred IA number 3. I'm sorry, minutes. IA number.
इनका तो मीटर चालू होगा DPS का.
Huh. Because during the pendency, I had filed IA number 4586 of 2014,
Yes.
challenging the bills which were raised during the pendency and the disconnection notice. But minutes, no order as such has been passed till date.
Basically, it is all the subsequent bills are sequel to this.
Yes, yes,
And you must have been paying your current bills.
absolutely.
Current bills at domestic rate or at commercial rate.
Minutes, whatever bill is coming,
You are paying.
minutes, I'm paying.
Okay.
I'm paying.
All the current bills are being
Current
paid.
bills are being paid.
And this is the
although-
area with DPS, which is the subsequent.
Although minutes, I have taken instructions from my client. Minutes, initially it was Dilip Kumar. Later on, since he passed away, I had filed a substitution which stands allowed. So I took instructions. Since now the energy bills are being served on NDS category, so whatever is the total quantum minus DPS and kept in abeyance amount, I am paying the entire. And ad hoc payments also I have made time to time.
It is a matter of accounting.
It's a matter of accountability. So now, Mills, I'll have to satisfy my lords that why I am before this honorable court at the first instance, and second, that if at all my tariff category only on the pretext that since I was running a workshop, Mills, is correct or not. Assuming everything against me, Mills, that I was carrying out workshop. In the counter affidavit, there have been some additions which has been made. I must point out to this honorable court. Minutes may come to
They
their counter
cannot
affidavit.
go beyond the inspection report.
They cannot minutes. That is what, and minutes, I must say that this matter should be taken up minutes for judicial interference for the statements which they have made in the counter affidavit. If my lord comes to paragraph,
You remain confined to your relief, right?
if my lords would come to the counter affidavit at paragraph 10,
Counter.
paragraph 10, page 3.
Yes. Read it, please.
May I please? That before going into the facts of the case, it is essential to state the history which gave rise to this case. Respondent number 5, along with other officer, visited the house of the petitioner after a complaint was lodged from the resident of the area. Upon inspection, in presence of the petitioner, it was found that petitioner is running a workshop for preparation of sweets behind the house for the selling through his shop located in the name and style of Fun and Food, and many heavy electrical instrument has been installed for the purpose. Now this is an addition which I say, Miraj.
This is absolutely, we can't take judicial notice of this kind of thing.
For the reason,
entire thing is based on this
inspection report.
and
Now,
the corresponding bill.
yes. Now they cannot make an addition in order to improve their case.
It's not possible.
Then minutes at page, paragraph 11,
Yes.
they say that the electrical connection was discontinued and the total connected load was since found to be 6 kilowatt. So the tariff category is being used. The bills have been raised accordingly. They do not say that any proceeding under 126 has ever been initiated till date. Then minutes at page,
Kasi, yes, respondent.
minutes only one paragraph, one more minutes. Paragraph at page 5, paragraph 12. Paragraph 12. The petitioner used loop connection from the direct main line for his uses, resulting in meter being stopped. The energy bills have been charged as per provisions of the tariff, and the provisional bill has been given on the excess load detected during the inspection, fully justified, legal, and as such recoverable from the petitioner.
Okay, yes, respondent.
This is all they say, madam.
You conducted an inspection.
Yes, ma'am.
It is your document.
Pardon, ma'am?
It is your document,
Yes, ma'am.
not in dispute.
Not in dispute.
So you conduct an inspection, you record everything.
Yes, ma'am.
Can this inspection report be supplemented by further
No,
allegations?
madam. May I start, madam?
Yes, yes, Mr.
Madam, my first objection would be, an inspection was carried out under section 126 manner, and a provisional inspection report was furnished to him, which he has signed. Thereafter, my lord, as it fell from my colleague,
This is
my
not
lord,
a provisional inspection
It's
report.
provisional.
This is a final inspection report. Load inspection report.
load inspection. The remedy available under him, to him was under 127, he did not exhaust that
No,
remedy.
you see, the process is
Yes.
that this is a load inspection,
Yes, madam.
on the basis of which you can raise a provisional bill.
Yes, madam.
The bill that you have raised is load inspection bill. It is not a provisional bill.
Madam,
It's a final bill. The breakup of this figure is not there. In order to justify this figure, you are making further allegations against him.
No, no.
And at the same time, you say that the bill is based on certain more allegations.
Yes.
This
No,
is
no,
not
no,
policy.
not more, madam. We have said, my lord, just,
And how, you see, in the residential premises, if a person is engaged in preparing something for the purposes of sale,
marketing.
the purposes of marketing, does it become a commercial premises? घर पे पूरी बना के भेज रहे हैं, दुकान पे बेचने के लिए, commercial?
Madam, if you not sit down,
You see, they would not even need a factory license for this, because for factory license also minimum number of persons are to be engaged.
But under the Food Safety Act, they are required.
Food safety as it act is a different thing altogether.
If lordship comes to para 12 of my counter, your lordship, the calculation part.
Yes.
Para 12, the second part of it, madam. It is pertinent to state here that the meter reading in the month of August 10 showed the consumed unit as 4108 units, and subsequently
Para 12 of the counter affidavit,
Yes.
right? Para 12.
second,
In reply to paragraph 890.
second part of it, madam. It
Second
contains the
part.
sub.
Okay, it is pertinent to state. Yes.
Meter reading in the month of August 10,000 showed the consumed unit as 4108 units, and subsequently in September it showed 46 units. The petitioner admitted that during inspection that as such signed the said inspection report. That day an inspection report, madam, which he might which I friend has
You
placed,
see,
madam.
these kind of allegations which you are making
It should have been in
in the
inspection.
counter affidavit is not based on any record. So nothing can be done so far as that is concerned.
Yes, madam.
What you can do at best is whatever is done, whatever is mentioned in the load
Inspection report.
and this breakup is also not there. So
Breakup is there.
your allegations, whatever, if he was found engaged in theft of electricity,
Then 135.
you should have done whatever you could have.
It was not theft, madam. We say unauthorized use.
This is unauthorized.
That is
Have
what-
you stated that this is unauthorized?
Yes, sir.
In the load inspection report?
Not in the loan inspection. The
But
counter
else-
clear.
ऐसा नहीं होता.
The lordship will see the inspection report, madam.
I've seen
The consumed unit is the load
You
is
satisfy us that if a person is preparing sweets
Yes.
at home,
it is a commercial.
commercial, satisfy us. Under what tariff and how will it come under what tariff?
Let it be tomorrow, but I will try to surprise.
Solely,
This is a point of law. It requires deliberation, madam. Let it be tomorrow. I am not playing much time.
Okay. Heard the learned counsel for the parties, the
Yes.
learned counsel for the petitioner, yes.
Only one request, please, because I have some personal difficulty tomorrow.
Aapka personal
Let it be Monday.
difficulty.
I am only praying for Monday, which I am not running away.
Okay, fine.
Only Monday.
Heard the learned counsel for the parties, the learned counsel for the petitioner submits that on 19/7/2010 at 4 p.m. One inspection was done by the respondent authorities and a load inspection report was prepared. He submits that the load was found to be 5969 watts and the basic instruments, the basic electrical gadgets being used in the premises has also been mentioned. He has submitted that the petition that it has been mentioned in the load inspection report that sweet workshop running in this camp. The learned counsel has submitted that immediately thereafter no provisional bill was raised and the premises was converted from the electricity connection in the premises was converted from domestic service to commercial-
Non-domestic.
to non-domestic service,
Yes.
and a demand of rupees 1,82,142 has been raised without any breakup. The learned counsel submits that it has come in the counter affidavit. No, it is an admitted fact on record that the sweets were being prepared in the
Backyard of
backyard of the
premises.
backyard was being prepared, but the point of sale was at a different place.
Yes.
The learned counsel further submits that merely because the sweet is prepared, the same cannot be a reason to convert a domestic connection into a non-domestic connection. He has further submitted that through the counter affidavit, some more allegations have been sought to be levelled against the petitioner, which is not borne out of the inspection report, and those aspects of the matter cannot be taken into consideration by deciding the present case.
Yes.
He has also submitted that no FIR has ever been
Yes.
instituted against the petitioner in connection with any theft or illegal use of electricity. The learned counsel, appearing on behalf of the respondents,
Let's
submit that the matter be posted. He prays for some time to satisfy this court as to whether a house where sweets are being prepared for the purposes of sale at a different point is to be categorized as non-domestic category. Monday?
Well, it's only one thing, since my learned friend has raised an issue of maintainability. This
No,
judgment is
इतना
governing.
पुराना 2010 का मैटर में
No,
अभी-
well, it's only because Sitaram Rice Mill governs the field, and Supreme Court has categorically formulated a issue that whether in 126 also a writ petition can be filed, and has given the authoritative judgment on this issue.
2010 writ petition having an interim order will not be dismissed on alternative,
Much of it, much,
right?
much.
Because we can see, Mr. Counsel, please appreciate. अभी DPS से तो ये कितना 50 लाख हो गया होगा?
No idea. I could not.
2010 से अभी तक कितना आपका?
1.5%.
10, हाँ?
1.5% है.
पर month. तो आपने 10 लाख तो बना दिया होगा।
बड़े आराम से.
जीने देंगे लोगों को कि बस यही सब करेंगे। घर में घुस-घुस के इंस्पेक्शन करते हैं।
Both have to coexist. Both have to coexist.
चोरी का कोई एलिगेशन, ठीक है?
Much.
मंडे फर्स्ट केस,
First.
10:30। आप टैरिफ वगैरह लेके आएंगे,
Because it's a part of the paperwork, the tariff.
जो भी है अपना सेटिस्फाई करने के लिए कुछ तो लेके आएंगे। आप ये देखेंगे कि फैक्ट्री लाइसेंस का जहाँ रिक्वायरमेंट होता है वहीं पे कमर्शियल शॉप होना चाहिए।
Absolutely.
आई डू नॉट नो,
Because under the Food Safety Act also, yes, there is certain requirements. I'll satisfy on that also.
जो फूड सेफ्टी में नहीं पहुँचेंगे।
Factory acts में.
Item 3, the rupees 7796 of 2012.
हाँ, सब थोड़ा दो।
Item 4, the rupees 2895 of 2013.
The order passed on the review petition filed before the learned trial court, which was rejected, is under challenge. Short fact, if my lord, in 2 minutes, if I can just submit, it was a suit between the two parties for eviction. Suit was decreed. I was not a party to the suit. Suit was decreed.
This is in our board, 227 वाली डेट हमारे पास
That is CMP is the latest trend, my lord. WPC is the old one. It is a so it is a WPC that is running in my lord. So it was a suit for eviction, my lord. The short fact then I will straight away come on to the illegality of the orders. So it was a suit for eviction between two parties. I was not a party to that suit. Suit was decreed. In the stage of execution, my father tried to become a party. The petition was dismissed. Then writ was issued for delivery of possession in pursuance to the execution. The Nazir went on to the spot and said that the property is not identifiable. And in his report, he says that the decree holder insisted for breaking the wall and taking the possession. That exercise was not carried. Writ was returned back to the court. Then re-writ was issued by the court. That is on merit of the case, that is not the issue involved. The re-writ cannot be issued once there is objection. Order 21/97 will come into picture. But anyway, re-writ was issued and my property was handed over to the other side, a part of my property. Pursuant thereto, I filed a petition under Order 21/97/99. That is as the Civil Procedure Code mandates. My miscellaneous case was registered before the court. Thereafter, in the year 2004. Thereafter, in 2011, in the
Are you
meantime,
ready?
yes,
I hope you are not seeking time.
Yes.
You are ready now?
Yes.
So, in the meantime, an application was moved by us before the court. That application was for summoning certain witnesses. That was rejected, and I was before this honorable court. My petition was dismissed. Anyway, in 2011, I moved an application seeking an amendment in my miscellaneous application. There were certain typographical error, but one issue that is of importance and how we have come here was that the schedule that I had mentioned in my miscellaneous application, that we tried to elucidate that. There was some areas and something that was there missing out, so that review application we moved. My review application was dismissed.
Review application or
Original
amendment?
amendment application. That was followed by the review application made in 2012. That too was dismissed. So these are basically
You are challenging the review order or you are challenging the refusal, earlier refusal?
I am challenging both.
Both in one writ.
Valid. If it would have been allowed valid, I could have challenged. They could have challenged one, but because both is, my prayer may be seen valid.
Order dated 22/2013.
Yes, that is under challenge.
That is only
That is under challenge because that was dismissed. So, well, and our contention, my lord, without going into the volume of the brief, my lord, if my lord, I can satisfy you, but that it is only elucidating fact. Then, because 2 pages, if I can just present from my memo, 1 page 59, just for a moment, if my lord. This is, my lord, the report of the Nazir. Just 4 lines from the last paragraph above 4 lines, my lord. 4-5 lines. If I just submit from here.
What do you want to show in page 59?
59 that I am showing, my lord, that the decree holder, this writ could not be executed for the reason that my property was under boundary wall. That is there, एक परवाना चाहर दीवारी के अंदर स्थित है. My lord, 4-5 line above the last paragraph. My lord has got it. फलस्वरूप वेद व्रत प्रसाद के अपने
तत्पश्चात डिक्री दार द्वारा
Yes,
हमारा पेज 59 यही है.
My lord, तत्पश्चात के ऊपर 5-6 लाइन देखिए.
हाँ.
My lord, I am just requesting my lord.
हाँ.
ये यहाँ से फलस्वरूप it will be my lord 33639 लाइन. फलस्वरूप वेद व्रत प्रसाद ने अपने घर के सामने साहित्य समाज चौक से जाने वाली गली सड़क पर से पूरब सड़क चहर दीवारी के अंदर स्थित भूमि को दिखलाने हेतु उसे परवाना का विषय वस्तु बताया, परंतु उस स्थल पर परवाना के अनुसार मैंने कोई कमरा अथवा उसका अवेश नहीं पाया और इस प्रकार खाली भूमि को भी पहचान करवाना संभव नहीं था। साथ ही उस स्थल पर प्रवेश का मैंने कोई रास्ता नहीं पाया। तत्पश्चात डिग्रीधारक के पति श्री वेदव्रत प्रसाद ने चहार दीवारी तोड़कर खाली भूमि पर दखल दिलाने को कहा, लेकिन परवाना में ऐसा निर्देश नहीं था। इसी क्रम में चहर दीवारी के अंदर स्थित आवासीय भवन से कई लोग चहर दीवारी के समीप चले आए। गिराने ऐसे व्यक्ति जिन्होंने अपना नाम योगेंद्र प्रसाद हुई पिटिशन बिफोर माय योगेंद्र प्रसाद चंद्रेश्वर साहब बताया, चहर दीवारी के भीतर से सभी लोगों के पूरा प्लॉट नंबर सो एंड सो, देन द डिस्क्रिप्शन इज गिवन बाय द प्रॉपर्टी. Now this is what my petition, if my lord will kindly see my review petition, amendment petition first of all. That is at my lord page 64, that's annexure 5 value.
Show me your first petition, then we will see the amendment petition.
Yes, my lord. That is at page 60,
Page 60.
64 my lord. Page 64 annexure 5. They start, it's long petition, my lord, but the first paragraph will indicate my grievance that is there, my lord. That the civil court, Nazir, beyond writ and in absence of advocate commissioner appointed on writ, in connivance with decree holder, executed writ DP on 1912.
First parameter, humble petition on behalf of objector third party, namely
No, no,
Yogendra.
that is first page, first paragraph, page 65.
First paragraph.
I am referring to first paragraph. That the civil court Najir, beyond writ and in absence of advocate commissioner appointed on writ in connivance with decree holder, executed the writ DP on 1912-2004 on the land and construction with Pakka boundary wall running from Chandra Mohan Prasad advocate to Nala and disposes the third party objector from actual physical possession in spite of written objection given in hand of the Najir on the spot by this objector on 1912-2004, available on record, which is his property, registered and executed by DC Palamu in the year 1933, while registered deed number so and so, while registered deed number so and so, in the name of grandfather of this objector. Now all the source has been disclosed, my lord. My lord will kindly come to
What is it that you wanted to amend?
the schedule, my lord,
Where is
because
that
this was a
schedule?
miscellaneous petition.
Where is the schedule?
That is how
Para
we
10.
have. That is how we made the application, my lord, for
Para
amendment.
10.
We have given the description of the property, my lord.
Where is it?
Para 9 onwards,
Yes. Para 10.
yes, 10. I'm sorry.
This is the description of the property.
Property
Okay.
that I have given here. Now,
This is what you wanted to amend.
yes, well, because schedule we cannot, because my lord, the process is that we have to file a miscellaneous application. Regular suit is not maintainable.
That's right.
That is bar.
This is the description.
Yeah, this is the
You filed a petition for amendment.
amendment,
Amending para 10.
amending and inserting schedule. That's why in my, because
One and
ultimately
the same thing.
because schedule is will be required for the purpose of execution. Unless there is a schedule, because
Your
it is not in a
Your schedule is the same as para 10.
no. We just added some more area to it. That is the point, my lord. If my lord will kindly come to annexure 8, that is page 118, my lord.
Yes.
119, my lord, if my lord will kindly have a kind look to, there is proposed amendment C, it will be relevant, my lord. These are the proposed amendment B and C, para 10 of page 5 after figure 28, the prior to the bearing, it we added renewed in 1939. 1928, renewed in the year 1939, and then para C is relating to area. That in para 11, on page 6, after figure 1277, it be added 1276, and after full stop 0.11 decimals to plot number 467 was transferred to younger brother of Vindeshwar Sahai for dwelling house for which document is being searched. That after para 14, schedule of the illegal disposed land be added. This is because schedule was missing, so this schedule we have proposed to add it.
The entire boundary is different. The boundary is different.
My lord,
But
Just a boundary is also.
that is their merit, but we have tried to elucidate because these are the document based on record. If we can establish, we have to satisfy based on our record merit. Because we
Can't
are-
be like this. It's just not permissible. You change the boundary also. Where is the impugned order? Where is the order rejecting your
Review.
amendment?
Amendment.
Yes.
In Annexure 10 it would be merit.
Yes, please read that.
Page 141. I'm coming. Should I place the operative partner?
Yes, you please. Sir.
Then it will be page 142. Heard both parties and peruse the case record. There is no doubt that this is not a regular suit, and the petitioner has filed the miscellaneous case under 21 Rule 99 100 101, read with section 151 CPC. Under 21 Rule 99, any person other than the judgment debtor may make application if he has not been dispossessed by the holder of a decree. The prayer has been made to remove illegal possession of the decree holder from the land dispossessed. The miscellaneous petition was filed in the year 2005, and the amendment petition has been filed in the year 2011. The petitioner of the petitioner dated 5/3 contains full description of the land he was allegedly dispossessed, and the proposed amendment is likely to change the area and boundary wherefrom the petitioner was allegedly dispossessed. The case is not a trial, rather limited question is under consideration. Accordingly, petition dated 11/11/2011 is disposed of as rejected. So, the finding to the extent, Your Lordship, that it is not a regular suit and limited inquiry, that is perversity valid. If my Lord will see Order 21 Rule 101 of CPC, it clearly says that issue has to be formulated, trial has to be conducted. If my Lord will just have,
Your amendment only has been rejected.
yes, that is their merit, but the court while rejecting it has said that I will not go into it because you have filed it with
So
application.
whatever you have filed, that will be taken to a logical end. But so far, your grievance is only in connection with amendment.
Yes, that is. So then, my Lord, if my Lord may indicate this fact to that extent, because my schedule is missing, specific. So whatever I have pleaded in my petition, because tomorrow if I get the relief also, my Lord, in absence of schedule with the execution, because twofold things will come. One, whether the decree was to that extent or not, which has been executed, and whether my right has been infringed.
Yes, you see,
That's
his
if,
amendment petition has been rejected,
yes.
and this order dated 17/3/2012 is not under challenge.
My lord, one thing would relax.
Is it under
I
challenge?
have filed
Yes.
counter affidavit, Your Lordship.
Yes, it is there,
Just
my Lord,
simply
if I
so
place.
Is it under challenge?
Further, my Lord will see the prayer.
Or
Further prayer.
17/3. So
Yes.
both these orders are under challenge. And what counter affidavit have you
Yes,
filed?
counter affidavit I have stated, Your Lordship. Petitioner has filed this instant or writ application before this honorable court, Your Lordship, by suppressing the fact entire issues has been already been adjudicated by this honorable court, Your Lordship, by filing WPC number 1554/2008, Your Lordship, which has been dismissed on 27/3/2008.
What was the impugned order in WPC?
Yes, Your Lordship. I have filed Annexure A. My counter affidavit is also filed entire issues को लेके पहले भी आया है.
Annexure A.
Annexure, Your Lordship. annexure of my counter evidence. And
Yes.
he travel up to apex court, your lordship. Annexure A series, your lordship.
So that petition was
Title should
ultimately
also
dismissed.
lost. Title
Which
should has
my
been
lord?
This,
also lost, your
No, no,
lordship.
my lord, will see what he's submitting, my lord, first paragraph. I had filed for summoning of the witnesses, that the very
No,
outset.
no,
I said.
annexure A.
Yes, that was dismissed.
What is it?
That was, I filed an application for summoning 4 witnesses.
Order
For very first-
rule and yes.
In my place.
Kindly refer to the impugned order which was impugned in the WPC. What was
Yes.
the impugned order in the WPC?
इन्होंने ये कहा नहीं अपने read
If first paragraph I place, my lord is having, a decree is passed in suit so and so, execution case 5 of 97. This, in 2005, petitioner objected the delivery of possession by filing objection under 2199, which was registered as missed case. In the meantime, 4 consecutive petitions were filed by the petitioner, one for summoning the Nazir for giving evidence, second for calling the record from sub-registrar, Medinagar, third petition for pleading the decree holder, and fourth petition was for calling documents for execution case. So these were my 4 petitions before the court below. From perusal of the impugned order, it appears that father of the petitioner first filed an application in 96 under 151 CPC against the execution of the decree, which was dismissed. So I tried to interfere in the execution stage itself, my father. Again, petitioner father filed second objection in 50, which was disallowed by the court. Again, on 21/196, petitioner's father filed a title suit filed in respect of the same land during the pendency of the execution case, with the relief for declaration at that decree obtained in the title suit is not binding. The said suit was also dismissed as it is not maintainable under Order 21 Rule 99 valid. Fresh suit will never lie in this. The court below therefore held that objection was filed only with the intent to delay the execution. So I was trying to defend my right. Now, if my lord, just for a moment, if my lord will see the scheme of the 21, Order 21 Rule 97 to 103.
No, you see, this is the same miscellaneous case number 5 of 2005.
There I filed. Miscellaneous
Yes,
case is
yes,
registered.
yes.
Miscellaneous case is registered as valid as 5 of 2000.
Five.
They challenged the maintainability that was dismissed. That it is not maintainable in this backdrop of the fact. Now, in this miscellaneous case trial, my lord, I moved an application for these purposes. This is an order of 2010. My 4 application I moved for summoning of the registrar's record, then a summoning of the witnesses, which the court denied, declined to give me. Against that, we came to before this Honorable High Court. Honorable High Court also dismissed it. Then here it is a case of amendment valid. I am not on this issue. Here it is a case where I have come for amendment purpose, limited to that. I am on trial. I was trying to, what actually has happened, valid, you will find from very first paragraph that execution case was of 97. And my all petitions in the execution case
You
was
just
of
tell
96.
us,
Yes, your lordship.
this miscellaneous case number 5 of 2005
Fine.
is pending or disposed?
Pending evidence has
Pending.
not come. Yes.
Pending
Right.
inquiry
We are only
evidence.
concerned with the impugned orders which are here,
Yes.
and then that whatever be the fate of the miscellaneous case, that will be taken to a logical end. Simple.
entire matters को लेकर के 2005 का miscellaneous case पे फाइल
That
किया उन्होंने
you
आया
see,
लॉर्डशिप
we can just simply observe
Yes.
that if that miscellaneous case is pending, that will be taken to a logical end. That
Yes, yes.
For that you should not have any objection.
Yes.
But this amendment is not going to be.
Yes.
We do not know what happened, what was the history. So many orders passed. We don't
पहले
know
भी
about-
इन्होंने आया था सेम
कोई
इश्यूज को
बात
लेकर के
Amendment
5 साल
के लिए, please.
अमेंडमेंट के लिए सर आप
As
एपेक्स
an
कोर्ट तक
officer-
ट्रैवल कर चुके हैं, ये आप अपने पाराग्राफ में लिखे नहीं
दुखी है इसलिए बार बार आ रहे हैं.
यस
दुखी है
ये
इसलिए
इन्होंने टाइटल शूट भी लॉस्ट किया है वो भी कहीं पर नहीं लिखे इन्होंने इनका कोई ग्रीवांसेस ही नहीं है उस
miscellaneous
टाइम पे
appeal में जो भी होगा miscellaneous petition में whatever you want to say you can say there. What is the problem about it?
One line before my lord starts dictating, one line, that if it is observed that I will
5 साल के बाद इन्होंने मिसलेनियस अगेन अमेंडमेंट
I can lead evidence on my right.
I will not say anything more. WPC number 2895 of 2013 heard the learned counsel for the parties. District petition has been filed for the following relief. The learned counsel for the petitioner has submitted that petition was filed before the learned court under Order 21 Rule 99 of CPC in execution case number 5 of 1997, which was numbered as miscellaneous case number 5 of 2005. In the said case, the details of the property with which the petitioner is concerned was mentioned in paragraph 10. However, another petition was filed in the miscellaneous case number 5 of 2005 seeking certain amendment. The proposed amendment inter alia related to area and description of the property as well. The said amendment was dismissed by order dated 17/3/2012. However, the petitioner was dissatisfied with the said order, and another petition was filed seeking recall of the order dated 17/3/2012, which was dismissed by subsequent order dated 20/2/2013. 13. The order dated 17/3/2012 as well as order dated 20/2/2013 are under challenge in the present proceedings. The learned counsel has submitted that the various documents produced before this court would reveal that the amendment was sought for only to rectify the errors committed by the petitioner, and so far as identity of the property is concerned, the same is not in dispute. He has submitted that the amendment ought to have been allowed by the learned court, and in spite of filing a petition seeking recall of the order refusing to amendment, the learned court has dismissed the same, and therefore it calls for interference under Article 227 of the Constitution. The learned counsel, appearing on behalf of the respondent, has opposed the prayer and has submitted that the description of the property, area, boundary, etc. is materially different from the main petition, which was filed as miscellaneous case number 5 of 2005. The learned court has passed a recent order refusing amendment and further has also passed a recent order refusing to recall the order rejecting amendment. He submits that the orders have been rightly passed and the same do not call for any interference. He has further referred to, he has also submitted that petitioner has suppressed material facts before this court, inasmuch as he has not disclosed about the filing of the earlier writ petition being WPC number 1554 of 2008, which was dismissed on 27/3/2008, in which the various litigations which were instituted by the petitioner have also been mentioned. The petitioner had also filed a title suit in connection with, had also filed a title suit being title suit number 5 of 1996. The same has also been dismissed. The learned counsel for the petitioner, he has submitted that the said order passed by this court has attained finality and the Honorable Supreme Court has refused to interfere with the same. The learned counsel in response has submitted that the order passed in WPC number 1554 of 2008 has nothing to do with the present proceedings, inasmuch as the present proceedings relate to amendment sought for in the miscellaneous application, miscellaneous case number 5 of 2005. after hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that the description of property which was mentioned in the miscellaneous case number 5 of 2005 as contained in para 10 and the amendment which was sought for was materially different. This aspect of the matter has been taken care of by the learned court by refusing to allow the amendment by the order dated 17/3/2012. The reasons assigned by the learned court is quoted as under. This court finds that the order dated 17/3/2012 is a well-reasoned order and does not call for interference in limited jurisdiction under Article 227 of the Constitution of India. This court also finds that so far as the subsequent petition seeking recall of order dated 17/3/2012 is concerned, the same has also been rejected by citing reasons as follows. इसको quote कर देंगे. This court finds no illegality in the impugned order dated 20/2/2013, refusing to recall the order dated 17/3/2012, passed in miscellaneous case number 5 of 2012. Accordingly, this court finds no reason to interfere with the impugned orders dated 20/2/2013 and 7/3/2012, passed in miscellaneous case number 5 of 2005. However, it is observed that the miscellaneous case number 5 of 2005 is certainly required to be taken to a logical end. The learned court is directed to do the needful.
Grateful.
ठीक है? Communicate. Needful in the matter, if not already discussed.
No, it is not. I have had instruction, even issue has not been framed.
जो भी है, जो
The
भी होना है,
yes.
it has to be closed, na?
Yes.
It will not remain pending for all times.
Since now Supreme Court has said, or else I would have requested that some time may be given. But now since Supreme Court has come up with the new timeline,
तो पहले आप लगे चुके.
Item 5, WPL 6387 of 2016.
Yes, petition.
Lordship raised were not approved.
Not today. What happened?
Lordship, arguing counsel has.
Who is your arguing counsel?
Mr. P.S. Peti. Suffering from fever, your Lordship, since 5 days.
When do you want?
After vacation, your Lordship.
Which vacation?
Winter vacation.
Puja vacation. This year, next year.
This year, your Lordship.
Which order have you challenged? The order is passed under which provision? Where is the impugned order? Take me to the impugned order. Where is the order of the appellate tribunal? This tribunal's order is especially incorrect. Who is your senior? Both of you are on the same page so far as taking time is concerned.
Mr. Manoj Tandon is my senior.
मैडम को आज अच्छा ऑर्डर नहीं चाहिए. अब अगला दिन क्या होगा कौन जानता है? बताइए कौन सा डेट बताइए, चूज योर डेट. Yes, tell us.
15 or 16.
The learned counsel for the petitioner seeks adjournment. The learned counsel for the respondent prays for passing. The learned counsel for the petitioner submits that the arguing counsel, Mr. P.S. Patti, has not come to the court as he is not well. Is this statement correct? Fifteenth को कोई objection है?
No, Lordship.
With the consent of the learned counsel for the parties, post this case on 15th of October 24 under the heading for final disposal. No further adjournment will be granted. Kindly note, no further adjournment will be granted.
Good night.
Item 6, WPC 1627 of 2017.
I'm not pressing this.
WPC number 1627 of 2017, learned counsel for the petitioner Mr. Ajit Kumar, on instructions of his client, does not want to press his petition. Accordingly, this petition is dismissed as not pressed. Interim order if any stands vacated, commuted.
Item 7, WPC 6511 of 2019.
And for the petitioner lawsuit, in the last occasion in lawsuit, you have asked that whether there is a notification issued by the state of Jharkhand in terms of section 8 sub clause 2. Yes, your lawsuit, this is a notification which has been issued by the state of Jharkhand. The counter has been filed by the state, your lawsuit. Annexure B and Annexure B will show that this is a
So what is the consequence?
the registrar of the cooperative society having the power of self-supporting cooperative society. That is the issued notice.
Where
That
is the
is the
notification?
notification issued on 2004 and 2006.
Where is the notification?
The state has filed it.
State has filed a counter.
Yeah.
I have not.
आपको
Supplementary
नहीं
counter.
पता होगा ना?
Copy नहीं sir हुआ है.
कोई आपका यही सब चलते रहता है, आपको कॉपी सर्व नहीं होता है, कुछ आपको पता ही नहीं
State
रहता.
को
Where is
पैसे नहीं
the
दिया होगा, दिया नहीं होगा.
where is the notification?
Supplementary affidavit your lordship. ये
Counter affidavit by respondent number
supplementary
7.
affidavit has been filed your lordship.
Rejoinder.
That
When
is
has
good.
that been filed?
यही
Where is
फाइल
the-
हुआ है स्टेट की तरफ से.
कब?
इसका टैग को
कब फाइल हुआ है भाई?
20th of September.
28th September 2024.
September
2000?
24.
September to
20 सितंबर को फाइल हुआ.
अभी
20 September.
20
आज कितना तारीख है?
आज तो
फाइल
26
हुआ है इसका कुछ?
20 सितंबर को हुआ।
कहाँ है? चेक करिए. नहीं.
On behalf of the respondent number 2 to 5.
Where is the state? आने दीजिए मंगा.
ठीक.
नोटिफिकेशन तो फोर्ज नहीं करेंगे.
नहीं स्टार को बोला असिस्टेंट स्टार के लिए मांगा गया था असिस्टेंट स्टार
देखो. We'll just find it.
ये
Just a
कॉपी है जो हम अलग से दे रहे हैं, इसका टाइप कॉपी भी है, जो फाइल हुआ है.
उनको दीजिए. एक कॉपी करा के उनको दीजिए. पास ओवर कर रहे हैं, 12:30 बजे आइए.
Item 8, WPL 2715 of 2023.
Yes, petitioner.
Lordship arguing counsel is on bail. He has instructed to take Paso.
Who is the arguing counsel?
Ranjit Kumar Sawa, he is to come from Dhanbad.
Where is he?
Train has diverted its.
He is in the train.
About to reach the Ranchi.
So he is coming for this case.
Lordship.
Ask him to stay tonight. Let him do it tomorrow. Okay?
पास ओवर कर देंगे।
मंडे को रख दिया जाएगा, फ्राइडे हो जाएगा तो
देखो ट्रेन में बैठ के आ रहे हैं,
वो हमेशा ऐसे ही आते हैं। Every time only appear in such person.
वो
I
जाते
know
हैं।
him, my lord, he is from Dhanbad. He's very good counsel, but he appeared in the same similar way. He caught the train in the morning, arrived here after doing the work. He back.
Used to return back. Let's see
Let
if
it
pass
on
over
Monday. I
कर
will
दीजिए।
inform you because tomorrow, my lord, we don't have a list for tomorrow. On
what is the
Monday,
matter? क्या केस है बताइए?
Shops and Establishment Act का केस है. I was his employee. I was terminated without giving any notice. So in violation to section 26, I was terminated. I approached the learned establishment regarding same, and my ESI case was allowed.
Only 1 lakh monetary compensation दिया है.
हाँ, और भी दिया है. जो
और क्या?
वर्किंग पीरियड जो हमको टर्मिनेट कर दिए थे वो भी मिला.
Back wages.
Because there was no notice for termination. In COVID time, I was thrown out without any notice. And my lord, he is also not complying the.
No, he has given you monetary compensation. Monetary compensation of 1 lakh has been
Yes.
given. What else has been given to you?
But else was the.
Only 1 lakh amount. No, only 1 lakh amount has been given to you. Nothing more. With 10% simple interest. Acha, he is also directed to pay 9,000 per month.
Yes. For the period on which I was out of the employment, as he discharged.
इसका record कर
Record इसमें आया.
आया है? कब करना है आपको? सुबह ट्रेन पकड़ने से नहीं होगा, प्रीवियस डे आना होगा.
Let's see, जब भी केस होता है वो टाइम से आ जाता है, 9:30 बजे तक पहुंच जाता है। आज कुछ रूट चेंज हुआ है तो
कब करना है बताएंगे आप?
पास ओवर कर लेते हैं।
Passover means second half. You can come in the second half. Come. आइए, आज वो आ रहे हैं तो आज इस काम को खत्म ही करते हैं. Second half come in the second half.
उससे अगर कोई डेट
2:15 बजे ट्रेन पहुंच ही जाएगी.
नेक्स्ट डे अगर करना है,
Yes.
कोई अगर नेक्स्ट डे
Monday को जो है.
आप समझ रहे हैं? A person is already on the train. He is on the way to the court. Why do you want to waste his time? Isn't it?
For case filing item 9, the LOPC is 1712 of 2021.
Yes.
May I please? Petitioner is seeking mandamus, my lord. The fact of this case that the petitioner having applied for a LIG plot for Medinagar, my lord, to the Hazaribagh Housing Board campus, my lord. He has been allotted, selected in the lottery, my lord. L91 plot has been given to him. Accordingly, the higher purchase agreement has been made, my lord. But till today, my lord, the possession of the land has not been handed over in spite of the deposit all the money.
The deposit is done.
Yes, all the money has been deposited.
Counterfeit.
So, ladies, actually, state housing board has to be the answer respondent.
Housing board is not a party.
Yeah, housing board is
This is the party. Housing board.
You are for the state.
I'm for the state.
नहीं appeal कर रहे हैं. Respondent number 2 को notice कर रहे हैं. Right? ये registry भी हो गई है आपकी.
Agreement. Annexure 4.
Just a moment. Annexure 4 is the agreement. This is the higher purchase agreement.
Yes, higher purchase agreement.
Registered.
Yes.
Okay. Then some dues were projected,
That has been already paid.
already paid. So where is your representation?
Representation starts from Lord Annexure 9. 9 page 61. series of representations has been given, my lord, time to time, but only they have just passing the time, my lord, and not allotted.
They have informed you that they are not in a position to hand over the property because there is no land left.
Yes.
Right?
But there is alternative lands are there. They are making a proposal for that. My lord, kindly have a look the annexure 5, my lord.
Annexure 8.
Annexure 8, sir.
दूसरे जमीन की अनुशंसा की गई है.
But
Right?
that same land has also not been given to me.
Alternative land has also not been given to you.
I am very happy with the alternative land, my lord.
Are you interested in refund?
My lord.
Are you interested in refund of money?
My lord, so, this is a LIC plot, my lord. So, the purpose of the man is only for the land, not for making a house.
That's right. देखिए WPC number 1712 of 2021. Learned counsel for the petitioner and learned counsel for the state are present. Counsel for the petitioner submits that the petitioner was issued allotment letter in connection with L91 by letter number 16 dated 29/4/2010 annexure 2 for in the residential colony of Housing Road Camp, Hazaribagh, after he became successful in lottery. He submits that a hire purchase agreement was also registered, and on 20/2/2015, some dues were calculated and communicated to the petitioner. The petitioner has already cleared all the dues, including the demand made subsequently. He submits that when it came to handing over the possession of the property, the housing board was unable to hand over the property in view of the fact that upon physical measurement, no plot was of that area and description was available on the spot. However, a recommendation was made for giving alternative plot. This happened by letter dated 25/9/2017 issued by the Executive Engineer Hazaribagh Division to the Nodal Officer Jharkhand State Housing Board Ranchi. He submits that in spite of the presentations thereafter, no action has been taken by the Housing Board and therefore he is seeking a mandamus. The learned counsel submits that the petitioner would be happy if an alternative plot is allotted to the petitioner. He has been deprived of his right to have the residence since 2010, in spite of the fact that entire money was already paid by the petitioner. Issue notice to the respondent number 2, for which requisites under speed post to be filed by the petitioner by Monday. Office to track speed post delivery closed this case on 14th of October. No, on 15th of October in the supplementary cause list.
For admission item 10, WPC 5815/8 along with item 11.
My lords, I seek permission to withdraw these letters. Why? My lords, these petitioners have undergone corporate insolvency resolution plan under the IBC, and the resolution plans have been accepted from the successful resolution applicant, and therefore these petitioners do not exist.
WPC number 5815 of 2008 with other analogous cases. How many matters are there?
3 matters. I have with myself the orders passed by the National Company Law.
Not required. I will simply say that you do not want to press it with WPC number 5865 of 2008. Learned counsel for the petitioner MS Lavanya Garodia Mittal seeks permission to withdraw these petitions. She submits that under instruction of advocate on record, Mr. M.S. Smith. Advocate on record one.
Mr. Nitin Kumar Prasad.
Mr. Nitin Kumar Prasad. These petitions are dismissed as withdrawn. Interim order vacated. Prayer vote. You need to put your signature. You need to put your signature.
Item 12, WPL 5248 of 2009.
Yes, petitioner. Where is the petitioner? Where is the petitioner? Mr. P.S. Patel.
Not some claims were not today.
Whom are you representing?
Mr. Suraj Kumar. I am on behalf of the respondents.
अभी एक हम लोग प्रीपेड वाला जजमेंट नहीं किया When do you want? I have allowed a writ petition. Have you seen that?
Based on the same facts.
Same.
Because actually there
This
was
judgment which has been referred to was subsequently set aside by the division bench of Honorable Kerala High Court.
But a similar petition was dismissed by this Honorable Court and also by the Honorable High Court of Patna. And there's a petition pending before the division bench before this Honorable Court. I have the copy of that order.
I don't know. But I have also passed an order. I have also passed an order. Just around 10 days. 10 days. 5-6 days.
I'm not aware about that order. I'll just look into it.
But councils are not aware of the orders passed by the court. Daily orders check nahi karte.
I did not check whether it was on the same facts and circumstances.
I have passed the judgment, therefore I know. What was the reason for non-payment? What was the reason for non-payment?
It was a very sick company. There was some financial problem.
Financial problem is not a ground in the case of this Dilip and this Dharmendra Textile. Dharmendra Textile has been
Overruled. But
no,
that
Dilip and Sharoff has been overruled in Dharmendra Textile.
in that case they were specifically looking into the IT Act and other provisions where the word used was shall.
You see, this principle of Dharmendra Textile has been adopted for PF matters also with respect to 14B. You have not seen the last order. These orders are all uploaded.
Actually, my senior was supposed to
Who
argue
is your
that
senior?
Mr. Suraj Kumar. He is not well, so he did not come to the High Court.
It's a lottery for you. I'm asking you to argue. This is the biggest lottery a junior can have. The senior is absent.
Certainly.
Then you have lost an opportunity. Great loss to you.
The date will be given in the next week.
Junior should read those files in which the senior is not likely to appear.
Actually, my lords, he was going to appear, but because of the ill health, he could not come to the hearing.
So therefore you should have read the file.
I was reading the file. I just
You look at that judgment. When do you want?
any date in the next week.
I joined in 1995. Filed my first case in 2001. Right? So, lot of patience required. You have missed an opportunity today. You don't know when will you get the next one.
Actually, it was some complicated.
Anyways, I don't want to say anything. It's for you to decide whether to read the brief or not. You could have at least, these judgments, you should have seen these judgments. Citation is also mentioned.
I have gone through Dharmin textiles and other cases, but I'm not aware of the judgment that my lords have just.
Subsequent judgment is also mentioned, 2022, Volume 4, SSC 516, which has followed the principle of Dharmin textile. चलिए कब चाहिए बताइए कब आपके सीनियर की तबीयत ठीक है
Next week.
नेक्स्ट वीक मंडे the learned counsel for the parties are present with upon the joint prayer of the learned counsel for the parties post this case under the heading for final disposal on Monday. No adjournment will be granted. इसका एक जजमेंट आप प्रोनाउंस किए हैं उसको कराइए रिसेंटली याद नहीं इसी में ट्यूसडे को करिए सप्लीमेंट्री
Item 13, WPL 7020 of 2011.
Yes, petitioner.
For short consider as Mr. Manish Kumar has to argue in the case, he is only listening to case number 1 in Russia.
215. Russia. Next. Where is the other side? Respondent?
Other side, employee provident fund.
Okay. So who will appear?
Union of India में पार्टी है लेकिन हम सब वाला पार्टी एम्प्लॉय प्रोविडेंट फंड
कौन appear करते हैं? Employees
कुमार सिंह
Sorry?
अभिजीत कुमार सिंह
Where is he?
4-5 दिन पहले फाइल किए हैं वो काउंटर हमको कॉपी दिए हैं
Okay, come in the second half.
Item 14, WPC 22 of 2012.
Yes, petitioner.
IA has been filed for amending.
What amendment?
Yes, first title, Manoj. First title of the writ petition.
Why?
Initially, it was filed by one Krishnanand Jha. He was then the secretary of Deoghar Pradesh Committee, Congress Committee. Dumka Pradesh Committee.
Well, in this case, I have one objection. As per the last order, this fact was
no locus.
Yes, we have. This is before the court order. Thereafter,
Claim has been raised that the property belongs to Indian National Congress. Yes.
Yes,
Why?
IA has been filed, Manoj, for amending the cost title.
No, you file a fresh case. Why should you amend that?
Manoj, it was not filed in personal capacity. Manoj, can you see that cost title? Present cost title.
the IA, copy of the IA has also been not just before all board. The copy of IA has not been served.
You are filed in your personal capacity.
It has not been filed in personal capacity. It has been
This is not
filed
the way.
as
This
vice
is not
president.
the way the description of cost title should be there. You are just disclosing that you are a vice president of Jharkhand Pradesh committee.
But I've given the statement on affidavit also. Para 3. And para 4 also.
Where is your authorization letter?
That has no, at present, Malats.
Where was, see, we have to see as to how the initial case was filed. You cannot come up with a authorization letter and then say that you and then seek amendment.
This objection perhaps has not been even taken.
They have raised it. There is an order to that effect.
They have not raised in the counter affidavit.
It
was there on last occasion orally they had submitted.
That is sufficient.
They have not taken this much, and this IA Mallat is not changing the nature and character of the writ petition.
It is changing the nature and character of the writ petitioner, not the writ petitioner.
But it's a respectful submission. When it's can you see the IA Mallat?
What is the nature of relief?
But there was a mutation in favor of the Pradesh Congress Committee that has been set aside ex parte by the DCLR after more than 25 years, and then we went in revision. In the revisional court, the DC has kept the proceeding in abeyance, directing us to go and institute both the parties to institute a suit. I have given a short list of dates on affidavit. So can you see that? And they were also directed to file list of dates. They have not filed. They have not complied the order of the Honorable Court. It's in the supplementary affidavit, page 11. Malaj will find.
IA is not on board. Where is it, the IA? अभी सुबह बोले हैं तो अभी तक 12:30 बजे तक उन्होंने को होश नहीं है.
I will also file this vendor if they are also not with us.
They are objecting your locus throughout. You see, they in page number 14. In page number 14 of counter affidavit filed by respondent number 4, 5, and 6.
Page number 14.
Roman 2.
That was in mutation proceeding.
Yes.
Mutation.
They are challenging your locus in the mutation.
It is not that I am seeking mutation in my name. It is mutation is in name of the Pradesh Congress Committee. This writ petition was filed in 2012, a coordinate bench has, after finally hearing us, had directed us to file a list of dates on affidavit. We have complied that order, they have not complied as on date. Both the parties were directed. And when the matter was heard before the coordinate bench on that day, no objection was taken.
It is recorded in black and white.
It is only the last day, last hearing they have. Otherwise, matters may kindly see there is another order. There was an order,
last just surprising if you know my learned friend is saying, last 3-4 occasions they had taken time for filing an interlocutory application for on the same point.
There was a suit and it also ended into a compromise.
Proceeding under 144.
You respond to the interlocutory application.
If you let them
You have not even provided them a copy.
No, I did not know, Manoj.
I will. He will. In the course of day, he will. I will.
Yes, yes.
The learned counsel for the parties are present. An interlocutory counsel for the petitioner submits that an interlocutory application has been filed for amendment of the writ petition in view of the order dated 11/9/2024, wherein an objection was taken with regard to the locus of the petitioner to file the present case. Counsel for the respondent prays for time to respond to the interlocutory application. The needful be done by 4th of October. You need more time. 18th of October. Pose this case on 22nd October.
Password case item 7, WPC 6511 of 2019.
In the counter, there is no notification regarding the our under section 6 of the self-supporting act has been. It is for only for registration. वो भी clear नहीं है. 6 is not. और बिहार गवर्नमेंट का नोटिफिकेशन इलेक्शन ये लगाया हुआ. There is no notification of the Jharkhand district.
Annexure A, this will
ये
continue.
बिहार का
97 का नोटिफिकेशन है ना,
लेकिन
then it will continue.
झारखंड का तो है
Need not be.
नोटिफिकेशन इफ झारखंड स्टेट में नोटिफाई करेगी स्टेट
नहीं,
करेगी
ऐसा नहीं है. You see, the earlier notifications which were issued by the state of Bihar, they continue to operate in the state of Bihar.
specific
in the state
notification
of
has to be
Jharkhand.
issued regarding appointment of the registrar, assistant registrar separate जाए. उसको वही कहता है कि स्टेट कमिटेड गवर्नमेंट जो है उसको करेगी. As per
This is the notification under section 6. Yes, you are the state.
Yes.
Place your affidavit.
Because it may kindly see annexure 1A,
Yes.
page number 6.
This has been issued under which section?
Under section 8 का द्वारा वन में प्रदर्शित शक्तियों का प्रयोग करते
Cooperative
हुए
Societies Act.
and thereafter also the annexure B lordship.
Annexure B is what?
Annexure B lordship in the second paragraph it is written विदित है कि विभागीय अधिसूचना संख्या 23 दिनांक 2004 द्वारा अधिकारियों को
ये 2004 का संख्या कहाँ है? Where is this notification?
This is not there.
मेरे पास
दिखाइए. और ये जो इतना ब्लैकिंग करके आप फाइल किए हैं, पढ़ के सुनाइए। रीड इट।
निबंधन संयुक्त समितियां झारखंड अधिनियम के अंतर्गत पूर्ण समिति सभी कर्मचारी संयुक्त निबंधन संयुक्त
नहीं, ये नीचे वाला जो कॉलम है, लास्ट वाला कॉलम नंबर 4।
पैरा 1 में ही लिखा हुआ है जो निबंधक सहायक समिति झारखंड राज्य अधिनियम के अंतर्गत पूर्ण शक्ति।
लिखा ही हुआ है पूर्ण शक्ति।
पूर्ण शक्ति, this is not related with the self-supporting society.
नहीं, ये तो है।
इसमें self-supporting में for registration only limited purpose.
नहीं, कहाँ लिखा है?
इसमें लिखा हुआ लास्ट साइड में, ये लिखा निबंधन है तुमसे। उसका सेकंड पेज पढ़ा जाए, सेकंड पेज पढ़ा जाए उसका, पेज नंबर 9। They have been निबंधन की, not for deciding the issue. Deciding the issue is tribunal.
जब उसको सारा चीज
बोले tribunal is there. Section 40.
This notification is issued under
No section.
Bihar Cooperative Societies Act. Okay. And not under Self-Supporting Cooperative Societies Act.
सभी
तो क्लियर कट द लेटर सोच क्लियर कट कि निबंधक सहयोग समितियां झारखंड अधिनियम के अंतर्गत पूर्ण शक्ति।
कौन सा अधिनियम?
अधिनियम ना ऊपर में लिखा हुआ है।
हाँ बताइए, कौन सा अधिनियम?
ये बात ही क्या बोलते हैं, स्वावलंबी सहकारी अधिनियम 1996, दैट इज एनेक्चर।
कहाँ इसमें कहाँ लिखा हुआ है? This document that you have said?
नहीं, इसमें नहीं, इसमें भी है 2007 के नोटिफिकेशन, दैट इज एनेक्चर बी, दैट इज लेटर नंबर।
इसको तो रिकॉर्ड पे लेके आइए ना।
It is for related.
नहीं, it has come in the record also. नहीं, ये उसमें नहीं, मैंने स्टेट का जो फाइल किया है, that is annexure B.
This particular document is not on record.
और
You
जो
file it.
2004 वाला ना,
Yes.
वो नहीं।
You file it. This is not on record. You see, we have passed a specific order that there has to be a notification under the self-supporting cooperative societies.
Yeah,
the assistant.
One thing, Your Lordship, Bihar Sarkar, Bihar government is also, but he has issued the notification in the year जो है सो 1997. ना एक मिनट,
This
1997.
1997 notification, does it confer any power?
My lord,
Yeah.
my lord,
Yes or
1996,
no?
as per the Jharkhand state has not issued any.
That's right. But in
Section 40 is there.
1997, the power has been conferred.
Conferred under section 40 is to
What two of them?
40 of the itself.
1996.
Tribunal is there for any dispute. Tribunal has not got.
Para 2 हम पढ़ के सुना
40
देते
देखिए।
हैं।
You just
Section 40 of the self-supporting act.
देखिए self-supporting societies act.
Settlement of dispute.
ये नोटिफिकेशन नहीं है हुजूर। उद्योग का
Assistant
अधिनियम
SR को power नहीं। Section 39.
The notification was to be issued under which section?
881, 82. Specific
82 में ही notification है,
नहीं, specific power
97.
रहेगा कि इसमें decide करें।
97.
नहीं,
82
ये तो
में ही।
बिहार का है। झारखंड का कोई
No,
नहीं है।
97 का notification.
बिहार का है।
So
Jharkhand
what?
has not
So
adopted.
what?
So that notification will continue.
And more so, जब अपॉइंटमेंट होता है असिस्टेंट रजिस्ट्रार का, तो उसमें पावर क्या क्या करेंगे वो लगा लिखा रहता है। हर असिस्टेंट
The
रजिस्ट्रार की
notification is there under section 8(2).
स्पेसिफिक एक्ट है कि ये रजिस्ट्रार ही कर सकते हैं और असिस्टेंट रजिस्ट्रार झारखंड कोऑपरेटिव सोसाइटी
Clear
कहीं
cut.
डिस्प्यूट है ही नहीं।
There is
देयर इज नथिंग, सिर्फ 39 है और 40 और कहीं रेज कर ही नहीं सकते।
Your Lordship, the
सेक्शन
notification
39
which-
और 40 में
the notification
Cooperative
which
Act of
has
48.
been issued by the state of Jharkhand, that is annexure A, in 1997, the para 2 clear cut says that उपयुक्त अधिनियम की उक्त धारा 8 का धारा 2 में प्रदत्त शक्तियों के अंतर्गत राज्य सरकार का अधिनियम सूची के स्तंभ 2 में अंकित पदाधिकारी को
You filed your petition under which section? You filed your petition under which section? Your petition was rejected, right?
No, my petition is not
assistant
rejected.
registrar allow किए थे.
अच्छा.
We appeal में book किया, बोले कि I have not got the power of tribunal is not there
Yes.
to.
The appeal was filed under which provision?
I filed appeal, my lord. But it
इनको
was
फाइल
rejected.
करना चाहिए था रजिस्ट्रार के,
रजिस्ट्रार का
because
power
he is
ही
the
नहीं है,
competent
power ही नहीं है, रजिस्ट्रार को
joint
power ही नहीं
registrar
है.
can file.
रजिस्ट्रार को पावर ही नहीं है. It is not a 35 Act. It is simply a 1996 tribunal has to decide the matter.
This matter
no,
which has
no
been
tribunal is there. अभी तक कोई डिसाइड नहीं हो पाता है. सिर्फ निबंधन के लिए पावर दिया गया. फॉर रजिस्ट्रेशन.
No.
यस, इसमें लिखा हुआ है. तो निबंधन की है.
अरे भैया उसको तो सब पावर दे दिया गया है.
बी में लिखा हुआ निबंधन है.
तो निबंधन ये तो खाली थोड़े है. उसमें क्लियर कट है कि निबंधन सहयोग समिति को अधिनियम के अंदर कोर्ट
provision he will decide the matter. Any such property जब उनको पावर ही नहीं है. 39-14 होता है सर. विलेज डिस्ट्रिक्ट को पावर नहीं है. Any dispute section 48 under 1935 and any dispute 39.
The notification which has been issued by the regular the state of Bihar which has the notification which has issued in the year 19 that has continued in the state of Jharkhand.
Decide dispute करने के लिए नहीं है, सिर्फ डिवीजन के लिए पावर.
I want to know the assistant, the petition which was filed before the assistant registrar.
Yes.
Was under which section?
No section. It was filed on the
No, on the basis of the direction given by the Honorable Jharkhand High Court.
झारखंड हाई कोर्ट का है कि जो सोसाइटी में लिखा हुआ है, जो बायलॉज में लिखा हुआ, बायलॉज में सोसाइटी में लिखा हुआ रजिस्ट्रार ऑफ सेल्फ सपोर्टिंग के पास फाइल करना.
नहीं
63 को
बायलॉज में लिखा हुआ है
63 उसी का नाम डायरेक्शन हुआ
कि any dispute can be decided by the between the by the assistant registrar. Yes. दिखाते बायलॉज.
ऑर्डर पढ़ लीजिए. ऑर्डर में पढ़ लीजिए.
You just this particular notification
Order
is not issued under the Self-Supporting Cooperative Societies Act. This notification is not issued under self. You state, you satisfy this court that he had the jurisdiction or he did not have the jurisdiction. According to you, according to your counter affidavit, he had the jurisdiction or he did not have the jurisdiction.
As per the notification,
Not as per the notification, as per your counter affidavit. You must have taken a stand whether he has the jurisdiction or he does not have the jurisdiction.
No,
the order which we have passed, in the order itself we have written because of the direction of the Jharkhand High Court, Honorable Jharkhand High Court, the application has been filed and therefore this application has been decided also.
So, I just want to know, in order to resolve the dispute in connection with self-supporting societies, what is the remedies? What are the remedies? A person cannot be left remediless, isn't it? You say that he did not have the jurisdiction or he had the, either you say that the impugned order is correct which says, are you supporting the impugned order or you are opposing the impugned order?
Your loss.
The petitioner has come with a prayer to execute the order passed by the authority. Respondent has not come before this honorable court. And Lordship, the respondent has filed a counter affidavit. And Lordship, may kindly allow to read just the operating portion of the order for which we
Let us see the impugned order for a moment.
It is not impugned order, Lordship. The prayer is for direction to implement the order.
After 10.
This order,
Page 23, the relevant portion is.
you read it please.
Page 23, Lordship. Last paragraph. अतः समिति के खाता से निकासी रकम निकासी पर तत्काल प्रभाव से रोक लगाई जाती है. समिति की सामान्य निकाय उपविधि की धारा 21 की दिशा निर्देश में विशेष आम सभा अधिसूचित कर नए बोर्ड का गठन कर समिति में लोकतांत्रिक स्वरूप बहाल करें. नवनिर्वाचित बोर्ड को यह दायित्व होगा कि वह अपीलकर्ता सदस्य श्री कौशल किशोर वर्मा, श्री रंजन कुमार, श्री कमलेश चंद्र देव, श्री विष्णु कुमार कर्ता, श्री कनक कुमार रॉय, श्री एस के दुबे, श्री देव कुमार चटर्जी, श्री एल आर के, श्री विनय कुमार, श्री मदन लाल वर्मा एवं श्री जनार्दन कुमार साहू को वरीयता के आधार पर पूर्व शर्तों के अधीन भूमि उपलब्ध एवं निबंधित कराएं। Thereafter, Lordship, the reply has been filed by the respondent number 7.
This is the order which the petitioner wants to execute.
Wants to execute.
Okay, he says that did he take any steps for execution of this order?
Lordship, may kindly see the reply filed by the respondent number 7.
Not the reply. Did he take any steps for execution of this order?
Lordship, direction was to the cooperative, registered cooperative society to वो प्रेस एक लोकतांत्रिक तरीके से बोर्ड का गठन करेंगे and thereafter they will allot the lands to the persons named in the order. Lordship. As per the respondent number 7's counter, they have called for a general body meeting in which election was held. The fresh board was constituted and thereafter they have said in the counter, Lordship, that as of now no land is available, so they have returned entire amount to the members with interest. This is the stand taken by respondent number 7 in its counter evidence. So this petition is limited to the execution of this order itself, Lordship, and the respondent has not filed any writ petition, so and they are also not challenging this order, Lordship. Therefore, by filing counter affidavit, they cannot challenge this order.
So this order has to be executed, has to be given effect to.
Yes, Lordship.
Who will give effect to this order?
Lordship,
Who will give effect to this order?
Lordship, the direction was upon the cooperative society, Lordship, registered cooperative society. And as per the reply, Lordship, it has already been executed, Lordship. The amount has been, as per respondent number 7's counter.
There is no direction to refund the amount. There is a direction for allocation of land.
But they in their counter, Lordship, has
They can't refund the amount. When there is a direction to allocate the land.
Allocated, my lord.
Land actually, land has been given to the Assotec for construction of the मतलब कि 5-story building. उनको देने के लिए Assotec को देने के लिए जमीन है। Not only that, हम outside of the court बोल रहे हैं।
Outside the court तो कुछ भी मत बोलो।
एक चीज
Please hold on.
And this registered cooperative society has not been made party in this writ petition. At least they should have been made party.
Then who is he representing? Whom are you representing?
I am representing the ये जो बनाया है जिनके खिलाफ ऑर्डर हुआ था. I am that party. It was added.
सहायक निबंधक.
No, added. I was added as respondent number 7.
Yes, the cooperative society.
Cooperative society, self-supporting cooperative society. Okay. And I have stated that there is no tribunal regarding dispute.
There is no dispute. There is a direction on you.
Direction upon जो हो गया उसको compliance कर दिया सब.
कहाँ से compliance?
ये सब काउंटर में लगाया हुआ है. Compliance कर दिया.
कब किए? कब पैसा पेमेंट?
2022 के आसपास में किए.
2022 में किए ना? डायरेक्शन 2016 में था.
2016 में था तो जैसे
2016 के बाद have you made any allotment?
Allotment बनाया है.
You must have made allotment.
Yes, इन्हीं का 3 आदमी को allot किया.
इनका क्या 3 आदमी?
ये बहुत सा केस फाइल किया.
Just a moment. The allotment was directed to be made to the persons whose name has been mentioned herein. Have you made allotment to any one of them?
Yes, there was a criminal case, criminal division में इन लोगों को direction दिया तो land दे रहे थे, they refused. बहुत लंबा कहानी. They refused to accept.
No.
Yes, yes.
They never wanted to give allotment to land. They never wanted.
You see,
इनको Assotec को building बनाने के लिए
who is the petitioner before this court?
Who is the petitioner? He is a filed FIR.
12 लोग हैं जो.
He has filed FIR.
12 persons. 12 persons.
7 में और 4 को मिल गया है 10 पॉपुलर था जब भी
ये 7 petitioners है, they are the same persons whose name has been mentioned in this particular order.
Order name mention जो है उन लोगों की जमीन हम लोग के पास है नहीं, उसके लिए हम लोग केस यहाँ किए हुए हाई कोर्ट में पेंडिंग है रीट और जमीन जो है जबरदस्ती कब्जा किया गया रीट इज पेंडिंग है 493 of 2019.
He is misleading to the court your lordship. There is sufficient land which has been allotted to Assotec for construction of those multi-story building.
No, that is not the fact.
Not only that your lordship.
इन लोगों की जमीन से हम लोगों ने वो जमीन जो कब्जा किया था उस पर वो बना रहा है हमारे जमीन पर नहीं.
If any member of the cooperative society who has purchased the land, he wants to sell the property, the executive जो है सो, the respondent is 7, demanding 30 lakhs.
अगर आप अपना stand बहुत clearly नहीं रखेंगे ना, तो CBI inquiry करवा देना.
30 एकदम.
When there is a direction to allocate the land to these 7 persons, as back as on 25/2016, what have you done to this?
जिसको land नहीं दे पाए I have to return money के land है नहीं मेरे पास.
No, no.
Land
I
is
just
not
want to know, after this order dated 25/2016,
Yes.
have you allocated land to anybody? Or you have
No,
allotted land to nobody?
No. No.
No, not of these. Have you allotted land to any other person?
No. Only इन्हीं के
नहीं,
दो
नहीं,
आदमी.
दूसरे को किए हैं.
नहीं, इन्हीं के दो
दूसरे को
आदमी.
कर दिया, अपना आदमी को
क्या
किया.
बोलते हैं?
मतलब
ये अपना आदमी को किए हैं.
FIR was not by 10. हम बोला कि जमीन हम जैसे हमको मिल जाएगा छूट जाएगा इससे तो हम आपको जमीन दे देंगे.
This is a fit case for hand over to ED and CBI.
फाइल हुआ था.
More than 100 crore corruption.
They have accepted कौशल किशोर वर्मा कि हम जमीन हम ले लेंगे. They denied to accept the land.
जो वहाँ परचेज किया है वो बेचना चाहते हैं 30 लाख रुपीस for no giving no objections के लिए मांगते हैं.
But they refuse to accept. ये अब पहले की बात.
Refuse to accept means
बोले
you
जमीन नहीं
wanted
लेंगे.
to give them land and they refused to accept.
हाँ.
No, never.
Where have you taken this stand in the counter
Criminal
affidavit? No,
criminal
we forget about criminal case. We want to know where have you taken in your counter affidavit that you offered them the land and they
No,
refused to
not
accept.
in the counter.
Then
This is the matter difficult.
Out of
It was
the
a law point. It was on the law point.
What
The
law
assistant-
point?
Assistant decided.
Law will come for the assistance of those. Law will never come for assistance of those who violate the law.
One order was election कराने का वो करा दिया हम लोगों ने.
No,
Audit
only
कराने का.
on paper.
We
Audit
are
कराने
not
का.
bothered about it.
इसको जमीन का था
These
audit
7 people are entitled to property by virtue of this order dated 25/2016.
केस हैज बीन फाइल्ड FIR कि हम 400 4000
अरे
16 देंगे नहीं देंगे पैसा मांगा गया था उस पर FIR कर दिया कि 2 लाख छप्पन से 4 लाख 16 हम लोग किए कि जमीन का दाम बढ़ गया. दे फाइल्ड FIR पर. FIR is still pending going on.
दाम बढ़ाएंगे नहीं, जिस दाम पे कर रहे हैं उसी दाम पे नहीं दीजिए.
उसका सीरीज ऑफ केसेस फाइल हुआ. जमीन हमारे पास कहीं नहीं है.
जब हमको अलॉट
जमीन रहेगा
करने लगे तब जाकर के केस हुआ कि
हम पूरा दे देते कितना वैकेंट लैंड है दे देंगे हम वैकेंट
और
लैंड है.
स्वावलंबी समिति है ना.
जी इस पर अपना प्रभाव रहता है.
कितना प्लॉट है?
एक भी है बचा नहीं. एक भी बचा नहीं.
कितना है टोटल?
टोटल एरिया में है
ये
सब
12 एकड़
200
का
आदमी को अलॉट कर दिया.
कितना?
200 आदमी.
200 आदमी को ना. सबका लिस्ट ऑफ डेट और डेट ऑफ
हाँ.
अलॉटमेंट प्रोड्यूस कर दीजिए.
हाँ जितना को अलॉट हुआ हम सब.
लिस्ट एंड डेट ऑफ अलॉटमेंट.
यस यस.
20 एकड़ 48 डिसमिल.
20 एकड़
हम
48
सब
जिसमें
देते
जमीन
हैं.
परचेज
Detail
की है.
कैसे-
खाली
कैसे-
अपना आदमी को ये अलॉट की है.
पूरा मेंबर को दिया है. और एक केस भी
अपना-
फाइल किया है जो मेंबर को दे रहे हैं बेच रहे हैं वहाँ पर क्रिमिनल केस.
केस करने के बाद जो
जमीन बेच दे रहे हैं.
अपना आदमी को अलॉट की है.
एवरीथिंग डज नॉट सीम राइट. ऐसा
पूरा
लग
दे
रहा
देंगे.
है.
पूरा दे देंगे. आई हैव गॉट ऑल द रिकॉर्ड्स. हम सिर्फ अभी इस पर लॉ पॉइंट पर आए थे इसलिए नहीं दिए. आई विल गिव ऑल द रिकॉर्ड्स. कितना का दिया कितना रजिस्ट्री.
जितने भी बाकी जमीन था सब एसो टैग को देकर के
एसो टैग को दिया ही नहीं.
मल्टी स्टोरी बिल्डिंग को
60 डिसमिल लैंड कब्जा कर लिया. उन लोग पर केस हुआ. हाई कोर्ट में केस पेंडिंग हुआ तब जाके हम लोग कब्जा
the member of the cooperative who has purchased their land, if he wants to sell the
सब इन्हीं लोग
property,
कब्जा करवा.
the cooperative society demanding 30 lakhs for giving no objection certificate.
कोर्ट ऑफ कोर्ट से बोलिए.
मैं तो ये तो
30 लाख कोई नहीं मांगा.
30 लाख हमसे खुद डायरेक्ट बात हुआ है अभी आपका कोऑपरेटिव सोसाइटी के एग्जीक्यूटिव से.
लिख के दीजिए.
आप लोगों को पता है ये सारा रिकॉर्डेड प्रोसीडिंग है. कुछ भी बोलते हैं.
यस सर.
Do you have any idea? Have some restraint in whatever you are saying. अब तो खुद विटनेस बन जा रहे हैं. You are a land broker.
No, I am not a land broker.
आपसे बात हुआ मतलब क्या?
वो एक मेरा दोस्त परचेज किया था. If he माने कि हम पूछे कि if he wants to sell the property for माने कि for giving no objections he wants 30 lakhs. For that I am saying.
The learned counsel for the parties are present. The learned counsel for the respondent cooperative society is directed to furnish the list of persons to whom the various property of the cooperative, of the self-supporting cooperative society has been allotted, with all details regarding their father's name, etc. And also the date of allotment.
Yes. Registration.
Yes.
Registered.
Date of allotment.
Allotment
Registration की बात नहीं कर रहे हैं.
हमको 98 में अलॉट
Date
किया.
of allotment and
रजिस्टर्ड के तो 98
and also as to whether any property was allotted to any person after the after the order dated 25/2016 passed in as contained in Annexure 1. The affidavit should also disclose as to whether there are any remaining property for allotment. लेके आइए.
Yes, yes, sir. Order passed by the school council.
इसको आप एफिडेविट में फाइल कर दीजिए. आप देख लीजिए, पता कर लीजिए इसको. Post on 16th October. The affidavit should be filed by 14th.
इसमें थोड़ा सा टाइम लगा 16 के बाद ये बनाना पड़ेगा.
22nd.
22nd
बहुत आराम से चेक करके बनाइएगा. एक भी एरर हुआ तो अच्छी बात है.
नहीं बना हुआ हम थोड़ा चेक करते हैं.
Item 15, WPL 4977 of 2012.
And also give the details as to who are in possession of the property.
Yes.
Yes. Jishnu? What is it?
Item 15.
Who's for the petitioner? Where is the petitioner? Arun Kumar. What is the matter?
It's an award of Central Government Investor Tribunal.
What is the ground of challenge?
They are challenging on the ground that the award is perverse. Basically, it's an award based on a settlement. Settlement is in Form H, and that is the reason why the tribunal has answered the reference against them. Just the workman, he was superannuated. He raised a dispute, and before the matter could be decided, a settlement was arrived at that he would be reinstated. Yes.
Yes, please argue your case.
Yes, the award.
What is your point?
My lord, the petitioner was reinstated, my lord, on the date of the 26/8/1992.
Reinstated.
Order of reinstated was the issued, my lord, on the
26/8/1990.
yes, my lord, Annexure 3, my lord. The conditions without back basis, my lord.
Then what happened?
Although thereafter, my lord, the petitioner was not allowed to join my lord in the office. my
Not
lord.
allowed to join.
Join my lord. And thereafter, my lord, once terms and settlement was made, my lord, with the as the form H.
What is the date of settlement?
24/3/1993.
24/3/1993.
93. And it was the settled. The period of absence they will be treated as dies normal.
Yes. Clause 3.
Yes, ma'am.
So you accepted this?
Yes, well, this the petitioner, my lord, they accepted this, my lord. But thereafter, he disputes the facts, my lord, and they went for the tribunal. At tribunal, they passed the word, my lord, like this.
When was the
Petitioner-
reference made?
Yes, my lord.
2004.
2004.
This settlement is binding on you, isn't it? The settlement is binding on you?
Tribunal says, my lord, the settlement is binding upon my lord.
Tell us what is the perversity in that finding?
Yes, my lord.
What is the terms of reference? पढ़िए तो हिंदी में पढ़िए, इंग्लिश में लिखा। हिंदी को इंग्लिश में लिखिए।
It is agreed that the Sri Bhuvneshwar Pandey, the ex-store clerk, to be taken into employment with immediate effect. It is agreed that the Sri Bhuvneshwar
No,
Pandey,
what is the terms of reference? Read the terms of reference.
terms of reference, madam,
Yes.
page annexure 5, madam.
पेज 45 में हिंदी में लिखा, पढ़िए। क्या राष्ट्रीय कोयलरी मजदूर कांग्रेस
क्या राष्ट्रीय कोयलरी मजदूर कांग्रेस की भारतीय कोकिंग कोल लिमिटेड की क्षेत्र एक्सटेंडेड झरिया क्षेत्र के प्रबंधन के मांग की कर्मकार श्री भुवनेश्वर पांडे को उनकी बर्खास्तगी एवं पुनर्स्थापन के बीच की अवधि अर्थात 26/8/92 से 14/2/93 तक के वेतन का भुगतान किया जाए तथा दिनांक 1/9/90 से उन्होंने स्पेशल ग्रेड में प्रोन्नति किया जाए उचित एवं अन्य न्याय संगत है यदि
The
हाँ
terms
तो
of settlement are binding on you. Why did you enter into settlement? Is it a fraud? No, that is not your case.
it's not the case, but he says on the pressure as because the
We will not be in a
the
position to
employees-
adjudicate.
the employees they were
Pressure.
harassing this petitioner, my lord, even after setting aside the dismissals of the dismissals order of this petitioner. Therefore, my lord, the pressures they signed the terms of settlement.
The finding with reasons reveal that the case has been disposed of in terms of the settlement.
Yes, ma'am.
Yes.
And the point, my lord, which was formulated by the tribunal, my lord, whether the payment of the salary, the page 8, my lord, the finding of the tribunal, my lord.
Where is page number?
Page number 40, my lord.
40. Yes, point number.
40, yes, my lord. Whether payment to salary to be made to workmen for the period of 26/8/1992 and 14/2/1993. It will be the dismissal of these statements and point to the whether the claim for the promotions to special grade clericals from 1/9/90 is justified. Dismiss the case was only on the ground of the 4H mark which was signed by the petitioner.
There is no perversity involved. There is no perversity at all. It's a very reasoned order.
Only because one of the ground of this petitioner, one of the was the even after the setting aside the order of the dismissal, so one of the petitioner was not allowing.
But subsequently you entered into an settlement.
Agreement one of the was the entered into agreement one of the in terms of the settlements, one of the pressure of the employer one.
These things cannot be attributed.
This is the case of the petitioner one of therefore. This is the case of the petitioner.
What do you have to say, Mr. Mehta?
And second point one of the for the promotion one.
So
how 1990 promotion can be given effect?
Already retired one of the 2017.
Based on findings of fact, we have a division bench judgment, similar issue, but your lordship is, there's no perversity. There's a settlement signed between the parties.
WPL number 4977 of 2012. Heard the learned counsel for the parties. This writ petition has been filed for the following relief. The learned counsel for the petitioner submits that the petitioner was dismissed from service and was reinstated wide order dated 26/27/8/1992 without back wages after entering into an agreement. He submits that the petitioner was not allowed to join, and later on he was made to sign to enter into settlement in Form H with following terms and conditions. Is Annexure 4 में terms of settlement. The learned counsel submits that the industrial dispute was raised and the matter was referred for adjudication. And the point raised before the learned tribunal, formulated by the learned tribunal, was whether the payment of salary be made to the workmen for the period 26/8/1992 to 14/2/1993 between his dismissal and reinstatement. Point number 2, whether his claim for his promotion to special grade clerical from 1/9/1990 is justified. The learned counsel for the petitioner submits that the impugned award passed by the learned tribunal is perverse and has not considered the plea of the petitioner, plea of victimization of the petitioner, and that the petitioner was not allowed to join his duty for a period of 6 months. He submits that in such circumstances, the petitioner was entitled to the relief, but the learned tribunal has decided the case primarily by referring to the terms of settlement between the parties. The learned counsel appearing on behalf of the state or respondent has opposed the prayer and has submitted that there is no illegality or perversity in the improved award, which has taken care of all the materials which were placed on record. He submits that the terms of settlement entered into Form H in statutory Form H is binding upon the parties. The learned tribunal has primarily based its finding on the terms of settlement. He submits that there is no scope for entering into factual dispute in absence of any perversity. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, the terms of reference was as under. On behalf of workmen, petitioner examined himself as WW1 and the management and the sole management witness was MW1. The learned tribunal, upon scrutiny of the oral and documentary evidence recorded as under para 8 ka bottom 1, 2, 3, 4, 5, and while para 9 framed the following issues. The learned tribunal, by considering point number 1, has discussed the materials and held that the petitioner was charge sheeted and had participated in the departmental inquiry on charges of theft, and on proof of charges he was guilty and was dismissed in 1992. And thereafter he raised an industrial dispute, being reference case number 71 of 1994, and he apologized and tried to settle the dispute. And ultimately the management entered into settlement on 24/3/1993 in Form H. And he was allowed to join on 30th of July 1996. The settlement was signed by both the parties and was held. It has been held that after his dismissal, the workman was reinstated without back wages, subject to the aforesaid settlement. And the allegation of victimization was denied on the side of the management. So far as the second point is concerned, the learned tribunal also considered the same by referring to the materials on record and found that there was a bilateral meeting of the management and the union held on 20th of December 1991, and it was resolved to consider the case of promotion after his acquittal from the charges under the departmental inquiry. That was a claim of the workman, but the learned tribunal found that there was no proof on the part of the workman that he was acquitted of the charges. Rather, he was dismissed from service on the proof of charges of theft against him. Since the workman was held guilty of the charges, he was not promoted on 1/9/1990 to the special grade clerical. But later on, he got his promotion since 1993. This court finds that after considering the materials on record, the learned tribunal has decided both the points against the petitioner. No perversity as such has been pointed out by the learned counsel for the petitioner to assail the award. Otherwise, also the award being a well-reasoned order, the same does not fall from any defendants according to the petition is dismissed.
Item 16
So findings quote करते हैं, issue number 1 and
इसका खाली प्रमोशन वाला जो फाइंडिंग था ना मैडम, इसमें जो था, इसमें जो बोलता है कि उसने ड्यूटी हेल्ड कर दिया, लेकिन उसका एनेक्चर 3 से ही है कि उसको सेटिस्फाइड कर दिया तो ऑर्डर ऑफ डिसमिसल से
Item 16, WPL 7287 of 2012.
petitioner.
Yes, I am here. Was the award of the industrial
Petition. I was appearing on behalf of respondent number 2 on instructions of Mr. Suraj Singh. He is going through some surgery, so I was praying for some time.
The learned counsel for the petitioner is present. Mr. नाम बताएं, आपका नाम बोलिए.
Paramveer Singh Bajaj.
Mr. Paramveer Singh Bajaj, advocate, submits that Mr. Suraj Singh, who is counsel for opposite party for respondent number 2, is unable to appear before this court on account of some personal difficulty. It can be posted.
He will take some time for recovery after.
Tell
4
me,
weeks.
after 6 months,
After 4 weeks.
the summit said the matter will be posted after 4 weeks. Pose this case on 23rd of October. As Thursday and at 24th of October. Under the heading for final disposal. Otherwise it is, right?
Yes, I think the LCR is also.
आ ही गया. We need the LCR for this.
I don't think so, but still अच्छा है कि अगर आ जाए, there would be some documents that would be required. Because your lordship, there is some queries. So
Final disposal.
Item 17, WPL 4059 of 2013.
Yes, petitioner.
On 9th of September 21, the Respondents' Council informed that the workman has expired and he was directed to furnish the details of the legal heirs which he has not furnished till date. And I must also indicate that my company is also under liquidation. On the merit, my lord,
You are not bothered about your liquidity.
yes,
You argue the case on merit.
on the merit, my lord, I will indicate.
It is just 25F order.
No, my lord, that is also one of the grounds of merit. If the terms of reference is seen, my lord, the term of reference, my lords, will find at page 39.
It is quoted in the impugned order only.
Yes. Now,
This Dunlop India has gone for liquidation.
yes.
What is this? Such reputed companies are going for liquidation.
My lord, the word used in the terms of reference is dismissal. Number 25F is a separate concept altogether. Then, my lord, when the notices were issued, that is, my lord, Annexure 1, page 30, if my lord may kindly see, the first time the learned court below issued the notice was on 12/1/2010, page 30.
Is it an ex parte order?
Yes, the management did not appeal because of the change in address.
And extra one is the notice.
Annexure 1 is the order sheet issuing my lord notice. Now if my lord will kindly come to
Any service report?
सर्विस रिपोर्ट इज इंडिकेटेड प्रबंधन की ओर से कोई पैरवी नहीं है, कामगार की ओर से हाजिरी दी गई है तथा समय की मांग की गई है, करने हेतु सच एंड सच दाखिल करने हेतु निवेदन किया है, वाद दिनांक 10/3/10, उभय पक्षों की WS दाखिल कर अविलंब करने हेतु प्रस्तुत करें। लेकिन प्रबंधन की ओर से कोई पैरवी नहीं है, प्रबंधन की ओर से कोई पैरवी नहीं है, इट डजंट रिकॉर्ड वैलिड सर्विस ऑफ नोटिस। That apart, my lord, the letter of confirmation which was my lord submitted by the workman himself and marked as an exhibit, that if is available, my lord.
We will not go into the merit. When the matter is ex parte, why should we go into the merit? We just want to see whether notice was served upon you.
My lord, no, notice was not served upon me. We I am also indicating one, my lord, factual aspect which is evident, that my lord, on 5/1/2010 the workman crossed the age of superannuation, and notices are issued, my lord, on 12/1/2010, and the award is of reinstatement. In a reference of dismissal.
आपको पता कैसे चला?
I'm sorry, my lord.
Where did you come to know? How?
There was
when
an
and how?
execution instituted under Section 29 of the ID Act before the CJM. Then we came to know about it.
The notices were sent at the same address. Must have been.
My lord, some of the known persons of the, my lord, management of directors, they informed that there is a pending execution against them. Then they came and inquired and came to know about the execution under Section 29D. That quashing petition has been allowed. It was initially stayed in the light of, my lord, stay granted in this petition, and then subsequently allowed on the ground that the workman has expired. Page 44, my lord, the
What is to be done? The workman is not here.
My lord, otherwise also on the aspect of my lord, being proceeded ex parte and the order, the award of reinstatement being passed after the age of superannuation. Notices itself were issued after the age of superannuation. That I wanted to indicate. Page 44 of the writ petition, my lord, that was Exhibit 2 by the workman. Paragraph 3, my lord, retirement from service is compulsory on attaining the age of 58, and for the purpose of your continuance in service, the high school certificate submitted by you, which indicates your date of birth as 5th January 1952, shall be taken as authentic evidence. Now, this was the exhibit.
He
And
has
as
himself submitted
yes, madam.
that he has to look for the details. He is not aware about the legal years. That was the submission recorded, and no substitution petition has been filed. So the proceeding being ex parte,
Yes.
we can set it aside because no adverse no adverse impact will be there on the legal years if we set it aside.
But then, my lord, that remand also is not feasible because, my lord, the honorable court is
Who
not.
will pursue their case? The legal years.
They have to finally ensure service of notice.
There is a direction for reinstatement
Yes.
with back wages.
Yes. Page 65.
Back wages for the period from?
That is not indicated. On the previous page, it holds that the workman has been dismissed from service without showing assigning any reason, which is arbitrary, illegal. So, holding the termination to be a dismissal and then passing a direction of reinstatement.
He was removed on 31/7/2007.
Yes. and he was removed in the light of the terms of engagement with a prior notice of 1 month. That is also exhibit, and my lord will find it at page 47 of the writ petition. So it was a disengagement in the light of the terms of employment.
If the workman has expired, whose duty is it to substitute?
My lord, it is my responsibility to substitute, but the my lord, details are to be furnished by the counsel who had appeared for the workman. Had the notices not been served, my lord, things would have been otherwise.
He was your workman.
He was my workman.
You must be having his service records. You cannot say that you have no details of the work.
But I try to get certain my lord, instructions if it is available, because an old matter and company under liquidation.
If you do not, you see, if the workman has expired, there is nobody to take the matter forward, even for execution. The matter can be treated as a business. Simple. That should be sufficient.
That would be sufficient.
Abated as against the concerned workman. ठीक है, एग्जीक्यूशन तो इसमें फाइल होने वाला है, पार्टी का कुछ आता पता है। WPL number 4059 of 2013. The counsel for the petitioner has submitted that the sole respondent, who was the workman, has expired. It is apparent from the order dated 9/9/2021. As per the submissions made on behalf of the counsel of the workman, he submits that no petition for substitution has been. The learned counsel has also submitted that had the petitioner given the details of the legal years, had the respondent given the details of the legal years, the petitioner could have taken steps for substitution of the sole workman. However, from the perusal of the order dated 9/9/2021, it appears that the counsel for the sole respondent informed this court about the death of the workman and prayed for time to furnish the names of legal heirs and successors as well as date of death. And he has also submitted that he has to search for the legal heirs and successors of the deceased who have left the address where they were residing. Today, neither the counsel for the deceased workman is appearing, nor any details has been furnished with regard to the legal heirs and successors of the sole respondent. The petitioner has also not taken any steps for the purposes of substitution of the sole respondent, whose the details of whom could be available in the records of the petitioner. In view of the fact that the sole workman has expired, the present petition is treated as abated. That's
Disposed accordingly.
disposed of.